Well, there are
I'm
cases.
just asking you to explain to me why having to prove you are who you say you are before you vote doesn't serve, you said it doesn't serve any legitimate state interest. I'm just asking you to explain that statement to me.
In this moment, Senator John Kennedy does what is known for asking straightforward, common-sense questions and pressing for direct answers. Sitting before him is Nancy Abudu, nominated for a lifetime appointment to the U.S. Court of Appeals for the 11th Circuit. Before her nomination, Abudu served as a senior attorney with the Southern Poverty Law Center, an organization often at the center of heated political debate. Senator Kennedy's line of questioning zeroes in on a key issue, whether standard election security measures are inherently discriminatory. What follows is a pointed back and forth that quickly becomes a test of clarity and conviction. Kennedy keeps his questions simple. The answers, not quite as straightforward.
So in the voting rights or civil rights context is a term that I haven't had to come across, but what I do know is that as a legal research and writer, and for sure confronting possibly new areas of law, I look very forward to doing my due diligence in terms of making sure I'm familiar with doctrines such as that one.
Do you know what it is?
So no, I'm not familiar with it sitting here today.
Incorporation law? Okay. Well, you're going to see a lot of it if you're confirmed on the 11th Circuit. Can Congress pass any law that the Constitution doesn't prohibit?
Based on the frame of your question, I would say yes, that sounds right.
So you think Congress has plenary power?
Well, I would first look to what the Supreme Court has said in terms of following precedent.
No, but I'm interested, if I could, Counselor, in your opinion, does the United States Congress have delegated powers or plenary power?
Well, the Congress has both, I would say, from my general understanding. Again, it depends on the context and the issue, but
Okay.
it is.
Can you explain the difference to me between strict scrutiny and intermediate scrutiny?
Senator, strict scrutiny is the highest level of scrutiny that's often applied in constitutional cases.
What's the definition? I'm sorry, go ahead. Excuse me.
So it requires that a state, when enacting a law or regulation, have a compelling governmental interest for doing so, and that the law is narrowly tailored to achieve that interest.
Okay.
And then intermediate, did you say?
Yeah.
Okay, so intermediate speaks to the issue of having a substantial interest or that is, or an important governmental interest that is substantially related.
Okay. Do you believe that the meaning of the Constitution is immutable, or does it change over time?
Senator, I would say that the Supreme Court in some cases has analyzed that issue, and the response really does depend on the context and the issue. But what the court does or has done in its approach, of course, is look to the plain meaning of a statute or of the Constitution, because that really is where the inquiry should start. And if the language is plain, then that is where the inquiry can end.
Okay, thank you for that. You were involved in a 2021 report from the Southern Poverty Law Center about voting in Louisiana. Did you say, quote, racist white Southerners, close quote, and, quote, hostile white voters and governmental officials in Louisiana continue to make local polling places and early voting locations threatening spaces for black voters? Did you say that?
Senator, I do not believe that I said that. I haven't read that publication in some time.
Will you help write it?
I helped to draft the publication and approved it, but I'm not familiar with that language.
No, okay. In that same report, did you say, well, tell me where in Louisiana local polling places and early voting locations are threatening African American voters. You said it, so which polling places?
So again, Senator, obviously I don't have that report in front of me to be able to read and remind myself of the examples that might have been shared. But what I can say is that Louisiana...
Let me cut you off because I'm going to run out of time, Counselor. Let me ask you one more. In August 2021, we're not talking 20 years ago, we're talking 2021, you were involved in another report by the SPLC. And you said that voter identification, photo ID to vote, is burdensome and does not serve any legitimate state interest. Do you really believe that?
Senator, identification for voting is something...
Yes, but first, do you really believe that? You said it. You meant it?
The Supreme Court in Crawford v. Marion County has already upheld voter ID laws as per se
Yeah, but you said it didn't serve any legitimate state interest. Do you believe that?
Again, Senator, without that language in front of me, it's hard to understand the context.
You said it. Here it is, August 2021.
Well, there are cases...
I'm just asking you to explain to me why having to prove you are who you say you are before you vote doesn't serve... You said it doesn't serve any legitimate state interest.
Senator John Kennedy asks what sounds like a straightforward question. Is requiring a photo ID to vote considered voter suppression? It seems like something that should invite a clear yes or no. Instead, the response shifts into a discussion about legal precedent and the role of a judge. The message essentially becomes, I can't weigh in on that, because of judicial ethics. But here's the tension. At this stage, Nancy Abudu isn't ruling from the bench, she's seeking confirmation to it. Senators are trying to understand her judicial philosophy and whether her past advocacy work reflects how she might approach cases. Prior to her nomination, she worked with the Southern Poverty Law Center, where she criticized certain voting laws as modern-day echoes of Jim Crow. Now, under questioning, she avoids characterizing those same types of laws in absolute terms. The exchange grows more pointed when the discussion turns to citizenship requirements for voting. Again, instead of a direct affirmation or rejection, the answer stays cautious and procedural. For supporters of Kennedy's approach, that caution looks evasive. For defenders of Abudu, it may look like an effort to avoid prejudging issues that could come before the court. By the end, the frustration on both sides is palpable. Kennedy presses for clarity. Abudu sticks to measured, nominee-safe language. Moments like this highlight a broader debate. Should judicial nominees clearly state their personal views on contentious policies, or should they avoid taking positions to preserve impartiality? That's the real question underlying the exchange.